I'm Joe Neerman. Get ready for today's dose of good logic. Set up! When we focus on a story, it's important to know who, what, where, when, why. This is true whether you're a reporter or you're a court and you're attempting to figure out what's happening. Only they don't call it who, what, where, when, why. Instead, they have different legal terms that are supposed to be used to determine these factors. And frequently, a case will be bounced out of court, dismissed, thrown out. And a plaintiff will lose their case for things that have nothing to do with what. And when I say what, I'm referring to what evidence there is. But they will lose a case because of who and where and when and why. But the court will never refer to it under those terms. There are different terms that the court uses. Let's look at who. Who is which parties are here before us? You have a plaintiff, you have a defendant. Are they the right parties? Frequently, this will get dismissed under the grounds called standing. You, as the plaintiff, do not have standing. You are the wrong who as to who should be bringing this claim. You do not have proper standing.
You don't belong here.
But when it's a plaintiff who's the wrong plaintiff, they'll say you have improper standing. That's the who. With respect to the what, as I said earlier, the what refers to evidence. What evidence do you have that can show us that your claim has merit? The when is what we call about when are you bringing this claim? Are you bringing this at a proper time? When refers to, is your claim premature? Maybe you haven't been damaged yet. If it's premature, we'll dismiss it. Maybe you took too long. Sometimes when it's legally too long, meaning the law doesn't allow you to go so far from the time of the incident and look back so far from the time of the incident to raise this claim, that's called the statute of limitations issue, and that will be a grounds for dismissal. But sometimes there is no statute of limitations issue. Instead, the court just decides, really by its own gut feeling, that you just waited too long on this. You should have brought this earlier. And they will dismiss that under a grounds called laches, L-A-C-H-E-S, laches. Laches just means you spend too long. You just kicked around. You should have brought this earlier. Usually they'll try and focus on things that have happened, incidents that have happened, which created or which changed because of your laches. Meaning, if you would have brought this earlier, other people would have done things differently. Because you waited so long, people have been harmed by your delay. So whether you're focusing on premature claim, that you haven't been hurt yet, you're just worried you might get hurt, or whether you're focusing on laches, saying that it's just too long, you've waited too long here, even though there's no statute of limitations, that's focusing on the when. When are you bringing this claim? When should you have brought this claim? Or when should you bring this claim? And that's the next element. Where is, which court are you in? Where did you bring this claim? Is this the proper place? Is this the right forum? A lot of times that will lead to issues called jurisdiction. When you go to law school, they tell you that jurisdiction is another word for power. Does the court have the power to do what you're asking the court to do? So frequently they'll say that the jurisdiction of the court that you're in is improper. Meaning, when you have a claim to be raised, depending on who the parties are and the nature of the claim, that will affect which courts are empowered to grant the relief that you're seeking. If you go to the wrong court, you're in the wrong where, in that case, the court has no power to help you. If you get into a car accident in Oklahoma and try suing in New York court's going to say, you're in the wrong jurisdiction. This is something that happened in Oklahoma, and we're not going to hear your case. Now, it gets a little more confusing when you look at federal court versus state court. And that also comes into the whole where. Sometimes you're supposed to be in state court and sometimes you're supposed to be in federal court. I'm not going to break that down for this video because that would be too long. However, my point is that the question as far as whether you're in the right courts, that is another issue, which frequently will come down as jurisdiction. And that too is another basis for the court to say to you that we're rejecting your claim. And finally, the issue of why. And when I say why, I mean, why are you here? Specifically, what relief are you asking from the court? What remedy are you looking for? If you're here, there's a reason that you're here. You want us to do something. So why are you here? What do you want us to do?
All right, just tell me what it is you really want and I'll get it for you, I promise.
And that too is an issue if they say, we can't give you the remedy that you're looking for. We can't give you the relief that you're seeking. In that case, that too is a reason to say that we're rejecting your claim. So that's your who, what, where, when, why in a legal sense. And frequently, and specifically with respect to the election and the dozens of court cases that have been brought forward, all Americans have cared about is the what. We want the evidence heard. We want relief. We want justice to be done. These cases that have been brought forward, the fixation of the court has been on everything but what. Not what evidence do you have, not what proof do you have to support your claim. It's been about who do you have standing? Where? Is this the right court that you should be here? When? Is it your case too early or should be dismissed for laches? And why? Are we really give such extraordinary relief? Is that something that's, is giving this sort of relief proper? And frequently, even if the answer is to the why is yes, it is proper, you have to realize that you're dealing with courts that are being run by judges and they're people. And sometimes they're just cowardly. It's scary to be known as someone who invalidated a state's election. That is something that takes brass cojones. It takes very strong fortitude to look at a state and say, this election where hundreds of thousands or millions of people have voted, we are going to toss that in the garbage. That is something that, even if justified, is a remedy that scares a lot of judges, that they're going to be known as the person who invalidated votes of potentially millions of people. If you're a Pennsylvania judge, or you're sitting on the Third Circuit, which governs Pennsylvania in part, you're being asked to throw out the votes of millions of people. That's a scary thing. History is going to remember you. And accordingly, because of that, frequently, courts will say, you know what, I don't want to deal with this mess. But at the same time, I can't deny that the what here is pretty compelling. And since the what is so compelling and the why kind of scares me, I'm going to try and find a way to get out of this. And the way I can get out of this is by fixating on the other elements. I can focus on the when. I can focus on the where. I can focus on the who. We need a judge who is not so afraid of the why that they refuse to look at the what. Because when they're afraid of the why, they're afraid of the remedy, they're afraid of issuing or being put in position to issue the remedy, they're very reluctant to actually look at the what. Examination of the what is precisely what every Trump supporter and every Trump voter has been waiting for. Because of the why, the remedy. Courts have been repeatedly saying, we're going to skip the what and try and find a basis to throw this out based on who, when, and where. And if we can find any sort of rationalization to avoid the why, that's what we're going to do. And that is a sad state of affairs. This has been your dose of good logic. If you like my videos, please like, share, subscribe, hit the follow button, ring the little bell. Otherwise, you might miss some golden work. Happy holidays, and I'm out of here.
I hate goodbyes.
Lloyd,